Hi there, this is Exeter's Community Law Clinic, and in this video I'm going to talk about the deposits and fees you may encounter when signing a tenancy. First, I'm going to talk about deposits. There are two main types of deposits: holding deposits and tenancy deposits. There are also a couple other types of deposits which are less common, and I'll talk about that later. After finding the house or flat you'd like to rent, the first payment you'll be likely to make is a holding deposit. But what is a holding deposit? Holding deposits secure a particular property before you sign the contract while the tenancy checks are completed. They normally commit you to taking up the tenancy, so make sure this is clarified by the landlord or agency before passing over your money. Before paying the holding deposit, you should have written confirmation stating all of the details regarding the money, giving clear advice on when and how the money will be returned, and what criteria allow the money to be kept and not refunded. The holding deposit can be no more than 1 week's worth of rent. For example, if your rent is £100 per week, then the holding deposit can be no more than £100. The holding deposit is fully refundable and should be paid back to you in one of three ways. It can be paid back to you in full when the tenancy agreement is signed. It can be used as payment towards your tenancy deposit, or it can be used as rent in advance. Once you have signed your contract, you will probably be asked to pay a tenancy deposit. Not all landlords require a tenancy deposit, but they are very common. Your tenancy agreement tells you what is covered by your deposit, but it usually includes missed rental payments, items missing or damaged, damage to property, and cost of cleaning. Make sure you check in your contract what is covered by your tenancy deposit. The tenancy deposit can be no more than 5 weeks' worth of rent. For example, if your rent is £100 per week, then the tenancy deposit can be no more than £500. Your landlord is not allowed to keep your tenancy deposit themselves for the duration of the tenancy. The money must be placed in a government deposit protection scheme by the landlord within 30 days of receiving your tenancy deposit. There are 3 different deposit protection schemes the landlord can use. These are the Deposit Protection Scheme, My Deposits, or Tenancy Deposit Scheme. It should be stated in your contract which one of these your landlord will use. If you are worried that your landlord may not be using one of these schemes, you can go to the scheme's website and search for your deposit using your name, address, and deposit amount. There are some other types of deposits in tenancy agreements which are less common. Deposit replacement schemes, also known as smart deposits, are a one-off fee paid by the tenant. This is smaller than a tenancy deposit, but is non-refundable and does not need to be protected in a deposit scheme. This insurance policy will cover damage up to the value of 5 weeks' rent. If you are classed as a lodger and not a tenant, then deposits work slightly differently. Landlords are not required to protect your deposit in a government scheme. If a dispute arises between the landlord and the lodger regarding repayment of the deposit, the lodger will have to take it to the county court to recover their money. In 2019, the government enacted the tenant fees ban, banning some unreasonable fees that landlords could previously charge their tenants. This new law first applied to all tenancies signed after the 1st of June 2019. As of the 1st of June 2020, this new law applies to all tenancies, no matter when they were first signed. This new law bans all tenant fees charged by agents and landlords, apart from the specified permitted fees. The permitted fees are shown on this page. Your landlord is obviously allowed to charge you rent, a holding deposit, and a tenancy deposit, as I have just discussed. They can also charge for payments associated with early termination of the tenancy, if the early termination is requested by the tenant. However, a landlord is not able to charge more than the rent that they would have received before the end of the tenancy. They could also reasonably charge a fee to cover any referencing and advertising costs that they have incurred because of the tenant leaving early, but they should be able to provide evidence to demonstrate these costs. If there is a break clause in the contract which permits you to leave before the end of your fixed term, your landlord cannot charge you an early termination fee. A landlord can also charge a fee for variation of a tenancy agreement. This fee is capped at a maximum of £50 unless there are costs to the landlord which are higher than £50, and these were reasonably incurred. Your landlord can also ask for payments in respect of utilities, communication services, TV licence, and council tax. If your rent is outstanding for 14 days or more, your landlord can charge you a late rent payment fee. Any fee charged by a landlord or agent cannot be more than 3% above the Bank of England's base rate for each day that the payment has been outstanding. A fee which exceeds this amount is unlawful. If you have lost a key or security device giving access to the property and require a replacement, your landlord can charge you a default fee. The landlord or agent must provide evidence in writing to the tenant for the payment to demonstrate that their costs in replacing the lost key or security device are reasonable. A fee which exceeds the reasonable costs incurred by the landlord or agent is unlawful. That concludes this video on deposits and fees in tenancy agreements. We at the Community Law Clinic wish you luck with your tenancy process. Please see our other videos, visit our website, or contact us by email if you wish to know more.